I dare you to fix me. I'm crossing the line again, falling.
Yes, call the case.
Calling the civil case number 911-88 for reconveyance, recovery of ownership and possession with damages.
Appearances.
Attorney LV.
For the plaintiff, Your Honor.
Attorney JMT.
For the defendant, Your Honor.
Ready?
We are ready, Your Honor.
So call your first witness for the defense.
May we call the witness stand the defendant, Your Honor?
Okay, swear the witness. So let us assume that he was against sworn to. Your witness, Mr. Counsel.
Your Honor, we are presenting our sole witness,
CG.
and this is being offered to prove that she executed a judicial affidavit, that she will also identify her judicial affidavit, and that she will also identify the documents that are mentioned in her judicial affidavit, and that her judicial affidavit will be her direct testimony in court.
Any comment from the plaintiff?
We will cross, Your Honor.
Okay. Your witness, Mr. Counsel.
Thank you, Your Honor. Ma'am witness, do you remember executing a judicial affidavit?
Yes, sir.
Ma'am witness, I have here a document which is a judicial affidavit.
Of CG.
Kindly look at the judicial affidavit and inform the court if this is the judicial affidavit you executed. Is this your judicial affidavit?
Yes, sir.
And Ma'am witness, on page 10 of your judicial affidavit is a name
CG.
and a signature above it. Whose name and signature are these?
Mine, sir.
Okay, thank you. Ma'am witness, in page 4, question 18 of your judicial affidavit, you have mentioned an order from the DNR. If you will see this document, will you be able to identify it?
Yes, sir.
I am showing to you Exhibit 1 marked during the pre-trial. And is this the document you're referring to?
Yes, sir.
Your Honor, the witness has identified Exhibit 1 marked during the pre-trial.
Noted.
Ma'am witness, in page 4, question 18 of your judicial affidavit, you also mentioned the certificate of finality. If you will be able to identify it.
Yes, sir.
I am showing to you Exhibit 2 marked during the pre-trial. Is this the document you're referring to?
Yes, sir.
Your Honor, the witness has identified Exhibit 2 marked during the pre-trial.
Noted.
Ma'am witness, in page 5, question 24 of your judicial affidavit, you mentioned a katibayan ng original na titulo bilang COURT2 014-00888. If you will see this document, will you be able to identify it?
Yes, sir.
I am showing to you Exhibit 3 marked during the pre-trial. Is this the document you are referring to?
Yes, sir.
Your Honor, the witness has identified Exhibit 3 marked during the pre-trial.
Noted.
Ma'am witness, in page 5, question 26 of your judicial affidavit, you also mentioned the declaration of real property with assessment of real property number 2010-03-05088. And if you will see this document, will you be able to identify it?
Yes, sir.
Ma'am witness, I am showing to you Exhibit 4 marked during the pre-trial. And is this the document you're referring to?
Yes, sir.
Your Honor, the witness has identified Exhibit 4 marked during the pre-trial.
Noted.
And Ma'am witness, in page 6, question 29 of your judicial affidavit, you also mentioned a survey plan with the number PSU-1-001234. And if you will see this document, will you be able to identify it?
Yes, sir.
Ma'am witness, I am showing to you Exhibit 5 marked during the pre-trial. Is this the document you're referring to?
Yes, sir.
Your Honor, the witness has identified Exhibit 5 marked during the pre-trial.
Noted.
Able to identify it?
Yes, sir.
Okay, Ma'am witness, I am showing to you Exhibit 7 marked during the pre-trial. Is this the document you're referring to?
Yes, sir.
Okay. Ma'am witness, in page 9, question 45 of your judicial affidavit, and Your Honor, the witness has identified Exhibit 7 marked during the pre-trial.
Noted.
Okay. In page 9, question 45 of your judicial affidavit, you have mentioned katibayan ng original na titulo bilang CARP 201400088. If you will see this document, will you be able to identify it, Ma'am witness?
Yes, sir.
I am showing to you Exhibit 8 marked during the pre-trial, and is this the document you're referring to?
Yes, sir.
And Your Honor, the witness has identified Exhibit 8 marked during the pre-trial.
Noted.
And Your Honor, we are already through with our witness and we are ready to rest, Your Honor.
Okay. Any cross? Let's have the cross first before we will rest.
We will cross,
Ay,
Your
okay
Honor.
po.
Good afternoon, Madam Witness.
Good afternoon, ma'am.
Yes, how are you, Madam Witness?
I'm fine, thank you.
If I may ask, how are you related with the plaintiff in this case, Madam Witness?
He's my younger
Objection,
brother.
Your Honor.
Good. What is
The
your
question
ground?
is already asked, Your Honor. It is already answered in your judicial affidavit, Your Honor.
I'm just
You
trying to
can
establish the
just answer
relationship.
a question, okay?
Okay.
Thank you, Your
Will it
Honor.
damage you if you
Your
will
Honor.
reiterate that he is the brother?
No, Your Honor.
Thank you, Your Honor. I will proceed. So, Madam Witness, how did you come to own this, the lot under dispute? I will rephrase the question, Madam Witness. How were you able to secure ownership over the disputed lot, Madam Witness?
Um,
Was that not indicated in the judicial
Yes.
affidavit?
Okay, Your Honor.
Do not be repeating if it is stated there how he was able to title it, okay?
Noted,
But
Your
if
Honor.
there is none, then you may ask.
Yes, Your Honor. Going back to question number 24 of your judicial affidavit, Madam Witness.
Better.
To question number 24 of your judicial affidavit, Madam Witness, it is referred here that you had secured a katibayan ng orihinal na titulo bilang CARP 2014-00888, and such is identified as an agricultural lot. Is this true, Madam Witness?
yes, ma'am.
In the conduct of your application for the title, Madam Witness, you have to secure the approval of the DNR. Is that right, Madam Witness?
As far as I can remember, ma'am, the DNR. Yes, ma'am. Yes, ma'am.
So you claim that the area then is an agricultural lot.
Yes, ma'am.
However, is it not true that a house owned by your brother
AC.
is already standing when the conduct of survey was conducted?
That lot was I know the
Please answer the question, Madam Witness.
what's the question again, ma'am?
House is already there when you made the survey, the house of your brother.
Yes, Your Honor.
Okay, Madam Witness, but how come that it transpired in the report of the DNR that you claim that the area is an agricultural lot, when in fact there is already a residential house that was put up during the time of survey?
Yes, the residential house is just a little. It's a shanty, and actually that was
Okay,
only.
At this point, the judge said, "Let her answer. Do not interrupt."
Shanti. Oh,
Yes, sir. Yes, Your Honor. There's a shanty. Yes, ma'am. There's a shanty, but there are kamote plantations around it, ma'am.
how come that in the lot that you are claiming a structure has been put up? Who owns the shanty, Madam Witness?
The shanty was owned by my brother, and I also have a residential house there, ma'am.
Do you remember executing an agreement with the plaintiff, Madam Witness?
Yes, ma'am. That is sometime in the year 2001, ma'am.
Yes, Madam Witness. I have here the agreement, and it shows that you agreed that you will be giving 500 square meters to your brother.
Yes, ma'am.
And the lot being referred to, covering the 500 square meters, belongs to your brother. Let me rephrase the question, Madam Witness. The lot that is being referred to covers the lot where the house of your brother is erected. Is this true?
Yes, ma'am.
Yes, Madam Witness. However, you had the agreed lot to be given to your brother titled under your name. Is this true, Madam Witness?
Yes, ma'am.
Aren't you aware, Madam Witness, that agreements that has been signed by parties and were acknowledged are binding among the parties?
I am aware of that, ma'am.
But how come that you had the lot titled under your name when in fact it is agreed that that lot should be given to your brother?
The lot that was titled in the agreement, it is written there that the lot is titled, then that's the time that we can give, or I can give, the 500 square meters to my brother.
So therefore, you agree, Madam Witness, that the lot that is under dispute belongs to your brother.
No, ma'am.
Madam Witness, you just claimed a while ago that it belongs to your brother and that you agreed that you will be giving that portion to your brother.
Your Honor, objection, Your Honor. It's already answered.
I will sustain your objection if another ground. It is misleading.
It's
Why?
misleading, yes, Your Honor.
Because what is supposed to be given only is 500, not the whole lot. Okay? So always specify 500. Okay? The others sa kanya. Okay? Only 500 is supposed to be given to the brother. Is that correct?
Your Honor.
Oh.
So let me rephrase the question, Madam Witness. In the conduct of titling the lot area, even the portion belonging to your brother has been made part of the area that you owned under the title. Is this true, Madam Witness?
Your Honor, objection, Your Honor.
On what ground?
The question has been asked and answered already in her judicial affidavit.
I will not sustain you. The objection there is the best evidence is the title.
Best
Okay?
evidence. Yes, best evidence.
Oh.
Yes, yes,
The
Your Honor.
document is the best evidence.
Speaks-
Do not
yes, Your
discuss the contents of the document because it is already there.
Noted, Your Honor. So, Madam Witness, how come that you allowed that your brother
AC.
will put up his house inside that lot?
Okay.
Objection, Your Honor. It's already part of her judicial affidavit in question 34.
Did you not read that?
I have read it, Your Honor, but I am trying to establish the ownership of the area.
Here, judge said that in asking question, you refer to the judicial affidavit and say question number 4 to make it clear, chronological, and not misleading.
Yes, Your Honor. Madam Witness, in question number 37, you claim that your brother erected the house upon your permission.
You answer.
Yes, yes, ma'am.
Does your permission signify that it is because you recognize that your brother owns the area?
No, ma'am.
But referring to the agreement, is it not that the area is part of the lot that is being owned by your brother?
Objection, Your Honor. The question is already repetitive and it has been answered already a while ago.
You may answer. Is it included in the agreement that should be given to your brother?
Yes, Your Honor.
Okay, thank you, Madam Witness. In question number 39, Madam Witness, you have identified a letter that has referred that the residence of your brother is in Taguig.
Yes, ma'am.
Hence, you are claiming that your brother is not a resident of the area where his house is situated.
Yes, ma'am.
But isn't it true, Madam Witness, that a person can have more than one residence?
Yes, ma'am.
Objection, Your Honor.
It's already answered.
Hence,
Okay po.
would it be possible that the permanent residence of your brother is actually in the area at Pico, where his house is constructed, and not at Taguig, as you claim?
No, ma'am. His residence actually is in Taguig, not here at Pico.
But how come that the plaintiff and his family is still residing in the area?
That's not true, ma'am. They are actually residing. All of them are residing in Taguig, ma'am.
Is it not possible that the temporary residence of the plaintiff is in Taguig?
Ma'am, the letter that was sent by the ROD is in Taguig. That is where it was sent because actually that is where they reside. My brother and all of his family.
No further questions, Your Honor.
Any redirect?
No redirect, Your Honor.
Just a question from the court. So, did I hear you right, Madam, that you will give the 500 square meters that was agreed only after the titling?
Yes, Your Honor.
So, can you give it? It was already under your name. Can you not give it already?
Your Honor, it was already titled in my name, so that is already mine, Your Honor.
It is why you have said a while ago that you will only give the 500 after it is in your name. Now that it is in your name, you do not like to give the 500 anymore.
Your Honor, I cannot, attorney.
Well, I just based it only your answer, okay? Because it raises my hair a while ago. It raised
Your
my
Honor,
hair.
Your Honor, he has been he has been protesting my title, so I got hurt of what he did to me, being a brother's, Your Honor.
Oh, so you don't like anymore because of what he had been doing to you?
Yes, Your Honor, because in the agreement, Your Honor, I told him that I will give the 500 square meters if after the titling. But how come that I am during the process of my titling, he's already protesting from DNR to he even went to the barangay and then to the DNR and then to the registry of deeds and then now here in this court, Your Honor.
You cannot forgive your brother? Okay. Anyway, so any redirect, no redirect, okay? So,
No redirect, Your Honor.
any more witness to present?
No more, Your Honor. We are through with our witness and we are ready to rest, Your Honor.
How many days do you need to rest?
Maybe be given 10 days, Your Honor.
How about the plaintiff? I did not yet receive any formal offer.
May we ask for the same period, Your Honor?
No, you know, in practice, the court had given you a period to file. If you did not file it during that period, the court will not admit already your formal offer. So, what will the court do? Dismiss your case. You have to make an explanation why. I do not know. I keep on waiting, and then I was not able to wait for that formal offer. Anyway, just submit the formal offer of the plaintiff and the defendant.
Yes, Your Honor.
Okay? Oh, di ba madali lang ang judicial affidavit? Ano bang? Bakit nahihirapan kayo? That is the innovation of judicial affidavit. Kaya, yes sir, yes ma'am. Ganun lang. So, who is testifying? The lawyer. Kung magaling yung lawyer, ilalagay lahat doon. Ang tatanungin lang, di ba ito yun? Yes sir, yes sir, yes sir. Oh. That's why we do not like to use it in the criminal case. On the criminal case. You know that after the preliminary investigation, the information will now be filed in court, and then the judge will evaluate the information and the evidence submitted by the prosecutor, and then after that, he will issue warrant of arrest if the accused is not yet arrested or a detention mitimus. Okay? So that is the determination of probable cause. And after that, after the detention of the accused, the first appearance in the courtroom is the arraignment and pretrial. In the olden times, it is only arraignment. Inutay-utayan. Kaya nadi-delay. They will set the arraignment today, and maybe yung pretrial, the lawyer and the fiscal will agree sa December na. So, mawawalan ng interest yung complainant, hindi na mag-a-appear, madi-dismiss due to technicalities. Or they will just set the arraignment, reset the pretrial for them to settle. Those are the old style before. But now, under the continuous trial rule, so you have to apply this, Mr. Bakyan. we will use the continuous trial rule. So our first hearing will be the arraignment. So call the case, and then appearances. Are you ready for arraignment? So the prosecutor will say, ready. The defense counsel, we are also ready for arraignment. And then arraign the accused. Now, what is arraignment? Well, you will not know this if you will not act. When I was a new lawyer, I do not know what will happen during arraignment. So I go to the other courtrooms and observe what is happening in the arraignment. And then tumayo ka lang pala. And then tell your client, not guilty ah. Pag sinabing guilty, pagalitan mo para babalik na rin. So the information will be read in front of the accused. You will stand, and then people of the Philippines versus ganon. The information will be read in front of you, and the first question after reading, the first question of the clerk of court is, did you understand? Okay? Why? So that we can comply with the rule personally, that he personally understood what was being charged of him. Okay? Did you understand what I read? Yes. What is your plea? Ganun lang. So, what is your plea? Dalawa lang yan. Not guilty or guilty. But in some instances, when the accused will just smile and do not answer, okay, the court will just enter a plea of not guilty. That's what Erap did when he was arraigned. He did not enter a plea, so it was the court who entered a plea for him because he do not want to talk. Okay. So that is arraignment. Now, another innovation in this continuous trial rule is if there are so many informations, isa lang yung accused. Example, siguro estafa, 100 counts na information ng estafa. Oh, because of the continuous trial rule, the accused counsel and the accused will agree with the prosecutor in front of the judge that only one information will be read. Imagine 100 information. Even if you will start at 7 o'clock in the morning, when will the arraignment be terminated? Okay? So, you will just sign a certificate of arraignment indicating that they agree that only one information will be read. Okay? Did that violate the rule of the confrontation? No. Okay. So those are the innovations. Okay, now, under the old rule, if the complainant is not around, hindi matutuloy yung arraignment, pre-trial. Okay? Sa arraignment, kahit wala yung complainant, matutuloy yung arraignment. In the arraignment, gustong makipag-plea bargain, kailangan i-reset to call for the complainant to give his consent. In the plea bargaining, the complainant should give her consent. Remember those principles. Okay. Now, in the pre-trial, the old rule, as I've said, the complainant should be there. Now, under the continuous trial rule, no more. as long as she was notified or he was notified. So notice, as long as she received or he received the notice of arraignment and pretrial, if he did not appear, pretrial will still continue. That is not a ground for postponement of pretrial. Okay, so in the pretrial, the trial dates will immediately be fixed. And if you did not use those trial dates, it will be deducted from your trial dates. You cannot ask additional trial dates unless there are reasons. That is why if I will ask trial dates, even if I have only 3 witnesses, I will request for 5. Reserve ko yung dalawa. If I was able to present my witness or use my 3 trial dates, at least pwede kong i-donate sa defense yung 2 trial dates ko. To hasten, pabilis. Okay? That is why we are having a promulgation weekly because of this continuous trial rule. Every Friday, we have a promulgation. Imagine that. Every Friday, because of this continuous trial, mabilis na ang trial, mabilis na ang hearing, how will you present your witness? Okay, I have given you the lecture. You know that testimonial evidence, you make an offer. Example, if you are presenting the private complainant there, may we call the private complainant, okay, swear the witness, and then your witness. The first move of the prosecutor is to make an offer, the oral offer, that he is the private complainant in this case, that he executed a sworn statement to support her complaint, that he will identify the accused, that he will identify documents, that he will tell to this honorable court what the accused did to her. Ganun lang. No, very vague. Para may liwi kang mag-ask ng question. And other matters related to her complaint. Huwag niyong kakalimutan yun. Yun ang shotgun. Para pag nag-o-object, it is included in the other matters, Your Honor. Those are the styles of old lawyers. Ay nagugulat yung mga bagong lawyers. We object, Your Honor, it is not part of the offer. Sasabihin ng old lawyer, it is part, I said, in other matters. Sustain, sasabihin ng judge, I want to listen to that other matters, sasabihin. Okay?